Yeah, it's good to be in the live stream. Hello, everyone. This is Scott Schneider. I'm a partner in Husch Blackwell's Higher Education Group. Before we begin, and this is the scripted portion of this, the rest of this, I have no idea how it will go. But before we begin with the scripted part of this, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'd like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. That was very creative. I was supposed to say I'm going to try to answer all the questions during the webcast today. We have so much material to cover. There's no way that's going to happen. But if you put it in the question box and I have your email address, I'll give you a response via email. Does that make sense? Are we all on the same page there? I appreciate your participation and certainly encourage you to submit any questions you might have. A PDF of this presentation is available in the resources folder. This program is pending approval for, and this is bold and underlined, continuing legal education credit to report your hours. You're supposed to click on the CEU icon at the bottom of the screen. A certificate of attendance, including course materials, will be emailed to you tomorrow, along with a recording of this. This is going to live on forever, but you will get a recording of this webcast for watching and sharing. So it is the Christmas holiday season, and sharing is caring, and you can share this with your friends and your families and your colleagues. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. Me, I am very resilient and hardy. Sammy Rajaratnam, who is my colleague on this one, he cannot handle any sort of criticism. So if you have anything negative to say, don't do the evaluation. We only want to hear very good feedback. Does that make sense? That's it. That's all I have for housekeeping items. Let's get started with our program. I'm Scott. I think I said that at the beginning, and I've alluded to this already, but for the first time, I am being joined by my amazing Austin colleague, Sammy Rajaratnam. He's an associate in the Austin office and has done a lot of work with me and others around higher education issues, and I'm super excited to have him participate with us today. Cool. Let's get right into it. So this is going to be, I have 57 minutes left to sort of talk about all the issues in higher education, sort of labor and employment law developments over the last year. And I think where I will start, because this is slide number 9, so it seems like a sensible place to start, is talk a little bit about sort of the big picture. I have no idea where, I think I went to a conference in Portland and heard the phrase meta trends. I have no idea what that means, but I liked it. I suspect what it means is, what are some of the overarching themes that we are seeing both in labor and employment in general, but more specifically in the world of higher education that we are steeped in. And I think the first sort of big picture trend, and I've done a few talks about this, is in terms of expectations, institutions of higher education the expectations for colleges and universities historically have never been more robust. The things that institutions of higher education are involved in, either because they're obligated to by law, state law, federal law, regulations, or the expectations of their community members, is historically unprecedented. If you were to go back 50, 60 years, for instance, just to give an example, the idea that a college or university may have a role in responding to things like dating violence would be sort of untenable, or even sex assault for that matter. So that's a good example. So expectations for institutions of higher education now, what we are either obligated by law or because of the expectations of our community members has never been more robust. There was this long history in America, and this is with respect to point 2, especially in court cases, and this goes back 200 years, of, hey, we're going to be very hands-off when it comes to evaluating decisions made by colleges and universities. We're going to give colleges and universities a ton of deference. Was especially true around student interactions, disciplining students, but also around discipline, especially around faculty and staff. And for the last 40 years, that era of judicial deference towards colleges and universities has been eroding. And so the practical impact of that, and if anything, I mean, I've said previously, it's like when I file a motion for summary judgment, maybe 10 years ago, on behalf of a university, I would almost always lead with court cases that went back 30, 40 years saying the decisions of institutions of higher education should be afforded some deference. I don't lead with that anymore because there's a robust number of cases that have developed over the last 40 years and really come to a head over the last decade where courts, state legislatures, federal regulators are much more willing either to second guess institutional decision making and or add on additional responsibilities and regulatory obligations. The third sort of big picture trend, and I'm based in Austin, and we certainly see that in a fairly profound way here in Texas, is that the culture wars around the country, which feel like they've been going on for 50, 60, 70 years at this point, are as intense as they've ever been. Sort of the accelerant around that is social media has made it a little worse. And institutions of higher education, and we see this come up over and over in a variety of different contexts, are at the center of all of these culture wars. And we'll talk about, what does that mean in terms of practical, but that's sort of a big picture trend. The last thing, and this is where I'll editorialize a little bit, I learned everything about civics. My civics teacher in high school and college will be very upset with me, but everything I learned about civics was from Schoolhouse Rock. And one of the things in prepping for this presentation that I didn't realize until now, and maybe it's why I have such an affinity for Schoolhouse Rock, is that if you know me, I'm a ginger, and the main characters in Schoolhouse Rock are gingers. You see the Schoolhouse Rock superhero and the guy, the young man here talking to the bill on Capitol Hill. But back in the day when I was growing up, and I'm much older than Sammy, if there was significant policy changes that would impact a broad swath of the American population, there was a process. You passed a bill, and that was a time-consuming process. And it was hard to amend those bills. It took time. And one of the big picture trends, not only for institutions of higher education, but nationally, is, especially at the federal level, we don't pass laws anymore. What we have is administrative guidance. We have administrative, regulations, regulatory interpretations. You go back a decade ago, think about the Dear Colleague letter in the Title IX world and how that changed things. And that's what happens at the federal level, and then we litigate over it in federal courts, sometimes in state courts. And even at the state level, what we see now especially, and this is part and parcel with the culture wars, seeing state governors, state legislatures push back on federal mandates that come from executive orders and all that sort of stuff. And the practical impact of that, number one, is that with every administration change, and this is why so many of our political battles are so robustly fought, we could have enormous policy changes that occur once every 4 years, and that makes life difficult, especially for complicated institutions like colleges and universities. The area where, and I'm so personally worn out talking about COVID, but I'll do it anyway, where we see this playing itself out as a practical matter right now is around the OSHA emergency temporary standard, also the federal contractor standard, the EMS standard, all that sort of stuff. And it's a great example of what we're dealing with and how it complicates this way of doing business now. Really, from a practical perspective, makes life pretty complicated. I won't go into all, I think everybody knows sort of the back and forth here, but big picture, there was a proposed federal vaccine standard. Initially, there was some signaling in a lot of states about governments and governors saying, we're going to fight this and all that sort of stuff. Texas, I think, and I apologize for this if this bugs anybody. It's not my fault. I just live here. Texas was at sort of the forefront of that, challenging some of this legislation. So we see this kind of process playing itself out. And as I think you all know, we also have, in addition to executive orders which conflict with the federal mandates that came not from actual passage of legislation, but temporary emergency standards and other administrative activity. We have conflicts with state-level executive orders, and then we have a whole ton of litigation over this. I have no idea at this point. So I've gotten calls for months now about, what are we going to do in terms of the vaccine mandate? Under the best set of circumstances, complying with that vaccine mandate in institutions as complicated as colleges and universities was, a fairly significant ask. And, what I've said is, basically just based on everything that's going on, it's sit, wait, see how this process plays itself out. I don't know. I have not followed as closely as maybe I should have. I know we've probably done 500,000 webinars on this. My understanding is that everything at this point is enjoined. Now, it could be in a month or 2 months or whatever the case may be that somebody says, the injunction has been lifted, you need to move forward. But this is like a great example. It's a high-profile example of how this new way of governing, which, frankly, we've been dealing with for maybe 15, 20 years, and it feels like it's on steroids now, complicates on the operational side our work. I think it's a great example. One of the things I was supposed to do as part of this presentation in order to help people get CLE credit is to have a poll question. I have to have 3 of them. This is my first one, and I think you can respond by clicking or whatever the case may be. When do you expect to get clarity about institutional legal obligations regarding vaccine mandates? Before January 1, 2022, before January 1, 2023, or C, LOL, which the kids tell me, is that lots of laughs, Sammy? Is that what that means?
No, but close. What's your vote here?
Laugh out loud, is that what it is?
It's laugh out loud. Is that the option you're taking?
Yeah, I'm with C. I think the pandemic will be well gone before we have clarity on what the institutional obligations are around vaccine mandates. Could be wrong, we'll see. But LOL, and the fact that I got what LOL means, typically, like if Paige, for instance, was doing this with me, she would say, "Yeah, you're a boomer." So I apologize for that. But yeah, who knows at this point? I mean, the clients that I've talked to, hey, let's come up with a way to sort of be positioned if we need to comply with these mandates that we are. But I'm not expecting clarity on this anytime soon. I'm sure that people that are far more well-versed in this that might have a different opinion. LOL, LOL wins. Nobody thinks we're going to have clarity by the end of the year. There are very few, 4.4% of you all are very optimistic people. I need more of you all in my life. Let's set up Sammy on this a little bit. One of the things that when the pandemic started, that I was sort of interested in is, well, the fact that we're now, it'll be interesting to see from a labor and employment perspective what the long-term impact of this is. And so one of the nitty-gritty areas where I was especially interested in seeing was everybody, once the pandemic started, or most everybody just started working from home. Hey, we don't want to be around each other, all that sort of stuff. And I remember litigating cases, and this goes back 20 years ago, and it was in the Fifth Circuit, which was pretty conservative. But there would often be employees who say, I don't want to go to work in person, I'd like to work remotely. And one of the positions we'd always take in that case is, no, it's an essential job function for under the ADA for employees to come into the office, and therefore you cannot work remotely, and we wouldn't be violating the ADA by denying that sort of request. And I said, that'll be interesting to see now, because the vast majority of people are working remotely, whether the calculus on that changes a little bit. And so, Sammy, do you want to talk just a second about this lawsuit by the EEOC?
Yeah, for sure. So this is a first of its kind post-COVID work from home deal. A lot of companies, including Husch Blackwell, sent their employees home for an extended period of time. We were all working from home, and we were, basically doing the same thing and doing all the same duties that we would do in the workplace at home. And so it kind of changes the calculus now. And so this is a kind of interesting issue that's coming up. This case, which was out of the Northern District of Georgia, involved ISS with the employer. It does not stand for in-school suspension, which I'm sure Scott had to attend several times as a teenager. Another ISS, this employee, actually all the employees sent home to work from home 4 days a week from March to June 2020. In June 2020, all the staff were supposed to return. There was one employee who had chronic obstructive lung disease and hypertension, and she requested an accommodation because of her disabilities and said that, she's at high risk for contracting COVID, and she requested to work from home 2 days a week. Her employer denied that and ended up terminating her. This case was brought by the EEOC saying you can't do that. We'll see what happens, but this could be a change. As Scott said, courts in the past have held that on-site job attendance was an essential function because most jobs require this personal interaction, supervision, et cetera, that can't be done in a home office situation. But now, since we've all kind of been working from home, things will change. Now, it's a little harder for an employer to say they can't do the same things they can do at home than they can do in the office. And so basically, it's going to be tougher. Employers are going to have to figure out how to justify requiring people to come back in the office. But if you have a disability and you need to work from home, need to work remotely, it seems like there's going to be some litigation about that. And so the EEOC in this case is saying employees should be permitted to continue to work from home, and that should be an accommodation that they can be granted.
Yeah, so interesting development, and at least from my perspective, one of the interesting long-term practical consequences of, for an extended period of time allowing employees to work from home. That's it. That's all the COVID I can tolerate. This is my picture of COVID fatigue. That actually I had hair like that probably about 9 months ago. But that's it. I'm not going to talk anymore about COVID unless you all want to talk offline about it. I hope that makes everybody happy. Keeping up 2021, going back just a little bit. So one of the interesting cases from the previous Supreme Court docket was around the extent to which Title VII protected employees from discrimination on the basis of sexual orientation and gender identity. In a decision authored by Justice Gorsuch, a majority of the Supreme Court came back and said, yes, the Title VII's prohibition on sex discrimination in employment would extend to protect employees from discrimination on the basis of sexual orientation and gender identity. I assume you all already knew that. Now, there were some questions primarily raised by, I cannot remember who in the decision, saying, well, what's the impact of this? What does this mean in terms of, does that mean you might not be able to fire somebody because of their gender identity or sexual orientation, but specifically around gender identity? Does that mean, what does that mean with respect to bathroom access and pronoun use and all that sort of stuff? And about midway through the year, the EEOC issued a guidance document which attempted to and did address those sorts of questions. There are four kind of key takeaways on that one. I don't know, Sammy, did you want to talk about this? I can't remember.
Yeah, I can take this one. So, sure. The first one is no harassment based on sexual orientation or gender identity, including harassment by customers or clients. And so there's, accidental misuse of a transgender employee's preferred name and pronouns. That would not violate Title VII, but if you're intentionally and repeatedly using the wrong name and wrong pronouns to refer to a transgender employee, that can contribute to an unlawful hostile work environment. That also says that you can't use customer preference to fire, refuse to hire, or assign work, which means taking away assignments from employees based on them being transgender. So, for example, it would be discriminatory to keep transgender employees out of public-facing positions just because you think your customers, they would have a preference against that. So if you're directing those employees towards certain other parts of the store, that would be discrimination under this guidance. The next point, you cannot discriminate because an individual does not conform to a sex-based stereotype. So if a transgender employee is dressing a certain way or presenting a certain way consistent with that person's gender identity, you can't prohibit them from doing that. That would constitute sex discrimination. And lastly, the bathroom issue. So if there are separate bathrooms, locker rooms, or showers for men and women, then all men, including transgender men, should be allowed to use the men's facilities, and all women, including transgender women, should be allowed to use the women's facilities. So you can't require employee to use a bathroom in accordance with their sex assigned at birth if that's not what they identify with currently.
Yeah, and that last piece is, I don't know how to put this, and I'm off of social media. It's the greatest decision other than marrying my wife and getting to work with Sammy that I've made. But I remember a couple of years ago, there was this big brouhaha on social media about who's going to be in the bathroom, especially here in Texas. And so perhaps not surprisingly, when the EEOC issues this guidance, there are a number of states who say, including Texas, we're going to sue because we think that guidance, especially around bathroom use, exceeds the holding in the Supreme Court case. So it'll be interesting to see how it plays itself out. But I mentioned the whole Schoolhouse Rock thing. Again, this is a really kind of interesting example. I mean, Title VII has been on the books since 1964, especially the prohibition around sex discrimination, which, if you know the history of the addition of sex, it was almost added in part by at least some to try to kill the Civil Rights Act. There have been over the years various attempts to amend Title VII to specifically include gender identity and sexual orientation as protected categories. Those would fail. But what changed the law was an interpretation by the court, and now what we see is agency guidance from the EEOC, not in the form, by the way, of formal regulations going through the notice and comment period, and then state law lawsuits challenging that guidance. And man, when we see that over and over again on really difficult issues, can make compliance and operational issues, especially at complicated places like colleges and universities, especially complicated. Playing this out a little more, this was an interesting lawsuit involving a professor at Shawnee State University. And at Shawnee State University, which I believe is in Georgia, there was a policy around preferred pronoun use. And this professor basically took the position, he was a philosophy professor, and said, and a devout Christian who said, well, I'm not going to comply with a preferred pronoun of a student, and was purportedly disciplined for that, or cajoled and told, you know, you need to comply with this policy, and ultimately said, hey, I refuse to do that. And you see the first bullet point here, and this is a case that goes all the way to the Sixth Circuit Court of Appeals. Basically, he was warned that if you don't use preferred pronouns, you will be disciplined. And he said, I have a First Amendment right, by the way, which is tinged with free exercise issues, to use the pronoun that I think is appropriate. There was a lot of conversation at the school level. One of the things the professor said is, hey, as a compromise, how about I not use any pronouns whatsoever? I'll just avoid pronouns altogether. And the school, at least according to the Sixth Circuit opinion, said the university refused to, in essence, accept that purported accommodation. It's a really interesting decision, and you can find it online if you'd like a copy of it. I'm happy to send it to you. But it's interesting, I think, for a couple of reasons. First off, if you read the decision, and I don't know what's going on in the Sixth Circuit, but man, there are a lot of decisions that come out in the Sixth Circuit impacting colleges and universities. And there seems to be almost this disdain for higher education decisions in that circuit. And kind of the lead paragraph, and I don't have it in front of me right now, it sort of drips a bit of disdain for colleges and universities. And so I would recommend you read it. The second issue, and I find this to be the more fascinating, it'll be interesting to see how this develops over time, but the intersection of First Amendment rights for professors when juxtaposed with the Garcetti decision. And so let me just talk just briefly about that. In Garcetti, I'll probably butcher this, but I'll do it fairly quickly. The issue was the extent to which public employees who are speaking within the course and scope of their employment are protected from discrimination or adverse employment actions because of their speech. Are they protected by the First Amendment? And in Garcetti, it was a hotly contested 5-4 decision. Justice Kennedy basically said, hey, look, even if it's a matter of public concern, if it's done in the course and scope of their employment, there are no constitutional protections here. And in that decision, Justice Kennedy, who's been super sensitive about deference to institutions of higher education, had a lot of dicta in there about the application of this to institutions of higher education. And there's a long tradition that goes back to the 1950s of recognizing the importance, especially in the classroom, of academic freedom, like what you say in the classroom and how you comport yourself in the classroom, that may be entitled to heightened constitutional protections under the First Amendment. And in the Sixth Circuit decision, number one, they ultimately side with the professor here and say, hey, look, this is protected speech. You're trying to compel his speech here in a way that violates the First Amendment. It's a little more nuanced than that. But secondarily, there was this concern about, or the defendants argued, Garcetti applies here because the speech was in the course and scope of his employment within the classroom. In the Sixth Circuit, and this has been a trend, this is also the position of the Ninth Circuit Court of Appeals as well, came out and said, Garcetti really doesn't apply in the context of classroom speech at the college and university level because their paramount considerations about academic freedom are, for lack of a better word, paramount. So really interesting decision. If you have some time to read it, especially if you're at a public institution, I recommend it. I could do like 30 minutes on that one to do it justice, but I think it's a really fascinating decision. Again, you see it all sort of play itself out, especially like the culture war issues in this case. There are people, on campus that are reluctant and willing to fight, and there are advocacy groups that are willing to advocate on their behalf. But it was really interesting. And oh, by the way, the lack of deference to institutional decision making, all of those themes we talked about early on are all in play in this decision. Let me talk, I'll just give I don't know why I have this particular picture of Joe Biden. That's literally, I think, the face I make when I check my email on Monday morning, and I should have found a more flattering picture of him. But if we go back to the previous administration, there was this very controversial executive order which banned diversity training about systemic racism. Again, no law, nothing like that, just an executive order. New administration, and there were a lot of universities going, oh my God, how are we going to comply with this, and all that sort of stuff. We get an administration change, and one of the first things the President Biden does, is rescinds that ban on diversity training, which I think I'm comfortable. I will say, I think it's good development. We then see at the state level, and so I'm in Texas, at the state level, nationally, there's been this issue, and it's like a phrase that's bandied about, critical race theory, and at some level, like it is a phrase that is encompassing a heck of a lot more than I think what actual critical race theory encompasses. Be that as it may, there's been this push at the legislative level to say, hey, if you have curriculum designed around critical race theory, which they define a certain way, or divisive topics, and whether it's curricular or training and all that sort of stuff, you can't do that. Now in Texas, at least for the time being, that has been limited to K through 12 schools. There are other states where there's some discussion, I believe in Florida, for instance, about extending that sort of legislation to colleges and universities for a variety of reasons. I think that would prove to be problematic from a constitutional perspective. But again, what you see is the previous administration coming in via executive order on this kind of culture war issue that universities are at the center of, issuing this very broad edict. A new administration comes in, says, get rid of that, disregard it. And then states, especially in, whatever the quote unquote red states, saying, we're going to legislate in this space. And so it'll be interesting. I don't see that dynamic changing anytime soon. And so we'll continue to navigate those issues in a variety of different contexts, some of which are completely unpredictable, certainly on a go-forward basis. One of the interesting issues, and we've seen a lot of discussion, like if I go to I spend a lot of time on the Chronicle of Higher Education and Inside Higher Ed and all of these pieces, and newspapers and journalistic activities, it's hard to go a week without some school talking about their endeavors around DEI initiatives, especially on the employment side. And I will just say, some of what is said makes me cringe as a lawyer a little bit. The case law and there's the Harvard case, which there's some conversation about, is the Supreme Court going to weigh in on affirmative action in the admissions context yet again, which would be, I think, at this point, the fifth time in 40 years weighing in on this issue. Always, by the way, in a way that's a compromise and doesn't provide a lot of very clear guidance. And so there's some discussion about, they're going to revisit this. They'll revisit it in the context of the Harvard case. And that might have some implications on the employment side. But there's also a conversation about, and this is really interesting, there aren't a lot of Supreme Court cases or circuit court cases talking about the use of affirmative action on the employment side and what's permissible and what isn't and all that sort of stuff. And so what we're seeing, at least anecdotally, are schools coming up with fairly robust DEI initiatives and advocacy groups going, wow, we think that's beyond the pale, and it's gone so far that it violates Title VII because it's tantamount to, and again, if you could see me in person, I'm doing air quotes, it's tantamount to reverse discrimination on the basis of race. There have been threats of that sort of litigation. I haven't seen it. We'll get letters probably every 2 or 3 months that we'll noodle through. I think one of the interesting things about this litigation, especially on the advocacy group side, and we see this in the Harvard admissions case, is, wow, they can really tie you up for a long time and make even somewhat maybe even frivolous or on the cusp cases very expensive. At Harvard, for instance, defense costs to defend the use of race in the admissions process apparently has cost the university close to $25 million up to this point. So one of the areas where I think there will be some developments next year, and at the end of this I'll talk about where I think we're going, will likely be, especially among advocacy groups, challenges to some of the DEI initiatives that some of these universities are proposing especially around employment. So it's a hot issue. And the other thing is, there's going to be a case probably coming to the Supreme Court on admissions. There hasn't been a lot of litigation on the employment side, so it'll be interesting to see how that plays itself out. Let's see. This is a really interesting case. I only gave you the interesting stuff on this one. We're doing a whole year of employment-related developments. Interesting case at the University of New Mexico. The short version of the facts is yet an untenured professor who gets terminated for violating the institution's sex harassment policy. And this was one of these cases, all of this ends up getting somehow in the public domain here because it's a public and probably subject to public records requests. Long story short, ultimately, the University of New Mexico, again, does an investigation, finds that this professor had engaged in sexual harassment and violation of institutional policy and terminates the professor. And so one of the interesting things that I was like trying to see how this would play itself out is there have been it's primarily in the Sixth Circuit, some cases involving student due process rights, especially around the right to cross-examination or the right to counsel in student disciplinary hearings, that I went, wow, that's a stretch. I know due process law really well, and I know the development of it from the 1950s, but man, we're going pretty far when we say the 14th Amendment of the Constitution and a student disciplinary action requires a right to cross-examination. And I was kind of interested to see in this case whether or not the 10th Circuit would extend that sort of argument. 10th Circuit, by the way, hadn't done that in the student context, but whether they would extend it to, in the employment context, to a faculty member. And ultimately, in this case, the court decided to pass on that. They said, look, this professor was given the due process that the 14th Amendment requires. He was given notice of what he was accused of. He was given a meaningful opportunity to respond to that. And oh, by the way, that included the right to have his attorney help him out. But there was nothing where the 10th Circuit came in and said, oh, he's entitled under the 14th Amendment and due process requirements to cross-examine the people who have accused him of misconduct. I think that's a correct application of the relevant case law over a 70-year period. And again, I was very interested to see if some of the gains around due process protections that we've seen on the student side would be extended to the employment side. And at least in this circuit court case in April of 2021, the court came back and said, nah, he got enough. So really interesting decision on that score. I'll talk about a Ninth Circuit decision, again, just briefly. So, and just to kind of frame the issue, because one of the developments I think we will see is around compensation and challenges to compensation systems next year. And so out at the University of Oregon, really, there was a professor, Jennifer Freud, who brought various claims specifically around compensation decisions, retention raises, that somebody said, hey, I'm about to leave the University of Oregon to go to the University of Texas or to some other institution, and to kind of woo that person to stay at the University of Oregon, a dean or a provost says, hey, we're going to give you a raise. And one of the things that she argued was that they had a practice, the University of Oregon, this was the argument anyway, that the University of Oregon had a practice of doing that in a way that discriminated on the basis of sex in violation of the Equal Pay Act, Title VII, and Title IX. She files a lawsuit challenging this practice and other compensation practices, including, her overall pay as compared to peers. Case gets all the way to the Ninth Circuit Court of Appeals, and long story short, the university loses its motion for summary judgment. There are disputed issues of fact, and ultimately, you can see here, this is a public record, the University of Oregon settles the case for $450,000. I'm starting, and again, this is very anecdotal, but we do a lot of work with a lot of different schools. I'm starting to see, especially again over the last couple of months, more and more of these sorts of issues being raised, especially, by the way, I'm seeing them within athletic departments around salary. So that's very anecdotal, but this is a case that gets all the way to the Ninth Circuit Court of Appeals where, ends up with a result that I think is pretty significant. Not only am I seeing this anecdotally, and we as a group seeing this anecdotally, with lawsuits and litigation, we're also starting to see, again, it's not as robust as I thought it would be under this administration, but time may tell as the Biden administration gets its footing, and maybe we get past COVID and all that. But we're seeing OFCCP start to increase its enforcement activity, and higher education, colleges and universities, and high volume employers, and Google, for instance, is an example, are super attractive in terms of evaluating pay practices, hiring practices, all that sort of stuff. And this Google case, there's a pay bias claim that ultimately Google ends up getting hit with. There's a letter determination saying how you discriminated on the basis of sex in setting compensation, and this impacts 5,500 employees. And ultimately, Google ends up negotiating a multi-million-dollar resolution to that. And again, there are a handful of schools that we're starting to see that are getting hit with audits from OFCCP, and it's high volume stuff, so it becomes attractive to them. And sometimes I think one of the common things we're seeing is that schools, in compiling their affirmative action data, that some of the practices and processes aren't as robust as you would have liked to have seen. So that's another, I think, over the year, I think Freud case plus some of the OFCCP action that we've seen is another fairly significant development over 2021. I'm post sports at this point. Other than I like to play them, and I'll ask you all at some point, I think I'm the best athlete at this point in all of Husch Blackwell, but I'm over rooting for teams at this point. One area that I think, in addition to COVID, that went through this sort of, we had this revolutionary experience, and we still don't know how it will all sort itself out, involves athletes. We start, and I know we've done webinars on this, and I've talked to many of you all about these issues. We start with the NCAA's Alston decision, which basically said, look, the Sherman Act applies here when it comes to our interactions with student athletes. And it's really interesting if you read that decision. They're sort of hinting throughout. They talk about things like monopsony power, which is the monopoly power over the labor market. And I'm reading that decision, and I'm going, wow, it's like the Supreme Court is saying our quote-unquote student athletes are employees. And it'll be interesting to see how that plays itself out, or if it plays itself out over time. But The short version of Alston was to say, hey, look, limits around education-related benefits, to the extent they are set by the NCAA, violate the Sherman Act, violate antitrust laws, and you can't do that, okay? But you can't read that decision and go, wow, it seems like there are some broader consequences to that. I just want to talk, though, a second about Alston and what the practical impact of that is. And I know Jason Montgomery is a superstar in this space and has done a lot of work with our clients on this, is talked about it extensively. I don't want to make this another conversation about it, but one of the interesting things, and we're starting to see this play itself out in real time, it will be very interesting to see what happens next year, is now a number of schools in response to Alston are coming back and saying, all right, we're going to enhance our education benefits. This is what we're thinking about. Retention benefits, like if you pass the semester and you stay for the year, that there will be, we'll give you a certain amount of money. I think Ole Miss, for instance, was prominent in that regard. I remember seeing an article. And so it'll be interesting to see, like, from a practical perspective, because that's expensive to do that, especially expensive in a way to do that complies with Title IX. It will be interesting to see where the money, and this is probably a Power 5 conference problem more than some of the smaller schools, but as schools start recruiting for student athletes, and I'm assuming this is going to be part of the pitch, it'll be interesting to see how it's paid for at most colleges and universities. And I think one of my concerns is this: we're in the very early stages of this and we don't know where it's going to end, is I think the obvious pool comes from what we pay. And I'm sorry, don't be upset with me, athletics administrators and coaches, but to me, the obvious place where this money is probably going to be coming from is from the salaries of coaches and athletics administrators. That this run for 50 years of ever increasing salaries for, especially, Division I football coaches, Division I basketball coaches, could this be the peak? I mean, are the economic dynamics of this changing in a significant way? And I think anecdotally, when we've had this conversation with peers or folks in athletic departments, I've said, I don't know how this is going to play itself out. I would be a little reluctant to make enormous long-term commitments to athletics administrators or coaches until we know how this all plays itself out. And so that to me is, like, from a labor and employment perspective, when we're negotiating contracts, that's maybe the most important implication of the practical implication of Alston. I will say this: I almost want to do a presentation that says one of the biggest risk management issues in all of higher education is how we negotiate the mundane coaches' contracts and how we can terminate them and what the penalty is for terminating them. I was sort of amazed. There was an article written by ESPN. I hope some of you all have seen it. But I was sort of amazed that over the last 10 years at FBS programs, that there is almost over $500 million, and that's probably the tip of the iceberg, that is dedicated to what's called dead money, dedicated to basically paying off coaches' contracts that, for whatever reason, were terminated early. And I was like, that's an enormous, I know it's boring, and we sort of take it for granted and assume, well, that's just the way this business works. But I'm like, that's an enormous risk management issue, like $500 million minimum over a decade. I mean, is an enormous risk management issue. And it'll be interesting, again, to see post-Alston, and I think this is a 2 or 3 year down the road issue. Do we rethink the way we compensate coaches? Do we rethink the way in which the terms of contracts play themselves out? And what do we do in terms of early termination provisions and all that sort of stuff? Because this seems like an enormous, when we talk about managing risk, this seems like a low-hanging fruit to sort of go, let's just negotiate maybe some different contracts. And look, for market reasons and a number of other pressures, that might be completely pie in the sky and impractical. But man, when you're talking about those sort of resources just going into the ether, it may warrant a rethink. Along the same lines, and so that's one practical employment perspective. As I mentioned, when you read the Alston decision, it's almost impossible, I think, to come away with any other impression that at least the Supreme Court, in writing that decision, was looking at our student athletes as employees. And I go, wow, it'll be interesting to see outside of the context of this decision if this has legs in other contexts as applied to other federal laws and maybe even state laws, think workers' comp and things like that. So around the same time, September of 2021, and this has been an issue, by the way, nothing has changed about the National Labor Relations Act in a long time, but with each new administration, the rules around this issue seem to change pretty dramatically. Under this administration, the general counsel at the National Labor Relations Board comes out and says, hey, look, those Northwestern University student athletes, and they talk about that case from about, I think it was about a decade ago or 5 or 6 years ago, but private university student athletes in certain settings, and there's some guardrails here, we view them for purposes of the National Labor Relations Act as employees covered by the National Labor Relations Act. And when we go back to the previous administration, for a variety of reasons, there was an ALJ and a board decision that came back and said, as a practical matter, we don't think you can unionize in terms of negotiating contracts and all that sort of stuff. But what makes this interesting is, all right, if they're employees under the National Labor Relations Act, what we are as an institution prohibited from doing is discriminating against them because they've engaged in concerted activity. And we're starting to see, there was an advocacy group on behalf of student athletes who filed an unfair labor practice charge. I think this was against the NCAA. I don't think that's going to have any legs. But again, student athletes, when we think about them historically, it's like they're students. There are no employment implications from that. And I think this year, especially with Alston and some of these other developments, one of which Samuel will talk about in a second, that calculus this year, I think, has changed, and it'll be interesting to see how it plays itself out next year and over the next several years. Sammy, did you want to talk about this lawsuit along those lines?
Yeah, for sure. So now we have a lawsuit. This is in the Eastern District of Pennsylvania, I believe, where a bunch of student athletes, I think it's a proposed collective and class action by student athletes, are claiming that they should be considered employees and therefore paid minimum wage. And so this actually survived a motion to dismiss back in March. They filed a motion to dismiss in March. It was recently denied in August. And so the schools were arguing that the athletes failed to state a claim by not sufficiently showing that the student athletes were their employees, which is a requirement for bringing a Fair Labor Standards Act claim. And so here we have the Department of Labor Regulations. The district judge ended up saying, used kind of a multi-factor test. Interestingly enough, he used a test that was evaluating whether interns are considered employees, and kind of used that with student athletes, and said that some of the factors weighed in favor of the student athletes being considered employees, and it was enough to survive dismissal. And so we have, some kind of points here. Division I sports were not conducted primarily for the benefit of student athletes, but rather for the NCAA and the school's monetary benefit, and a couple other things here. Interestingly, kind of what Scott said earlier, we traditionally think of student athletes as students. There's some interviews for some of these plaintiffs where they say, everyone says you're a student athlete. I really think it's athlete-student. The game comes first. Another plaintiff was saying, he was at this university to be an athlete. Without being an athlete, he wouldn't have been there, and he was there to take whatever class he needed to take to continue to play. And so, whatever you think about that, what your opinions are, it's pretty clear that I think in our culture we do elevate student athletes, we do elevate athletics, and so it's just interesting to see where this case will go now that it's survived dismissal on its face, at least, to see if these student athletes will be considered employees and can bring this claim.
Yeah, and I'm seeing in the chat, I apparently said Shawnee State was in Georgia. I'm an idiot. Hey, I apologize. It's in Ohio. And so that's in the 6th Circuit. Georgia's in the 11th Circuit. But well done, Sammy. This is the most important poll question you will do all day today. I'm telling you right now. There's a lot of money riding on how you respond to this one. Which Husch Blackwell education attorney do you think is the best athlete as of today? I'm not talking about in the past. As of today. Who is the best athlete? Your options are Jason Montgomery. Probably he's not a real good athlete. Just my opinion. Paige Duggins-Clay. I've seen her. I don't think she's a really good athlete either. Haley Hansen. I don't know. I haven't seen her in competition, so I'm not in a position to evaluate. But then D. Scott Schneider. This guy, I'm not trying to prejudice you or guide you in any way, but my hunch is that's the winner here. But what do y'all think?
See, I don't know. I've seen Scott Schneider play volleyball. I can't speak to the other three, and I think you kind of touch the net a lot. At least that's what I've heard.
All right. Well, there you go. But will you also point out that I'm also a two-time defending champion? How do we calculate the poll results here? How does this work? Do I just do this?
I think so.
Yeah, I won. Let's shut the polls down. I don't want to get the mail-in ballots or anything else. I've won. I am victorious yet again. 35%. Can you screenshot that, Sammy, for me?
You left me out of these with these results.
All right, but if you could screenshot that for me, I just won an enormous bet, and we're closing the polls, folks. So I win. I am the best athlete among Husch Blackwell education attorneys. Oh, my favorite, one of the great bands, musical groups of all time, the Supremes. What's going on at the Supreme Court? A lot of interesting things involving higher education, some directly, some on the fringes. Talk about just two really quickly. We've got the Hughes versus Northwestern University, which I think the oral argument was yesterday, and I haven't read the analysis of it and see how everybody feels things, the predictions, all that sort of stuff. But a couple of years ago, maybe it was 3 years ago, there was a firm and they were suing a lot of colleges and universities saying, if I look at your 401k or 401(b) or your retirement plans, you're doing a lot of things that breach your fiduciary obligations. And Northwestern had one of those lawsuits. A ton of schools had one of those lawsuits, and they prevailed. I think it was in the 8th Circuit Court of Appeals. Case goes up to the Supreme Court, and the Supreme Court, I think fairly soon, maybe in the next several months, will probably issue an opinion where they outline, what are the fiduciary obligations. Specifically, I think, in that case, this is around fees that were charged to participants in programs, and whether or not if you have a fee set up that's substantially higher than maybe alternatives, is that in essence a breach of fiduciary duty under ERISA? That will be an interesting case to follow. And again, I think oral argument on that was yesterday. I'm pretty sure it was this week. So it'll be interesting to see how that plays itself out. There's another little case, and I'm surprised it hasn't gotten more attention than it has, but there was oral argument on this case last week, which is Cummings versus Premier Rehab Keller. And there are some implications here. The short version of this case is like under a statute like Title VI of the Civil Rights Act of 1964, is compensatory damages like a breach of contract damage that has historically been afforded to damaged parties. And there was a Fifth Circuit case where the court said, no, compensatories, emotional distress damages are not the sorts of damages that have historically been recognized in breach of contract claims, and therefore they're not recoverable in Title VI cases. That would have, by the way, implications for Title IX as well. Again, the oral argument on that was last week. my reading of scotusblog.com was that it looks like the defendants in that case have an uphill battle, but that's a potentially significant case for institutions of higher education. We are coming to the end, and so I wanted to give, and I'm right on time, look at me. I wanted to give some thoughts about, what to expect. And I've sort of hinted at this for 2022. And so some of this informs planning, like what are we going to be focused on from a labor and employment perspective for next year? COVID ain't going away, so that's part of it. By the way, on the left, that's not me, although that beard looks a lot like me. That's Nostradamus. And so here are my 5 thoughts about where we're going next year. To sort of guide planning a little bit. So first off is that labor and employment cycle. One of the great things about being a labor and employment attorney, and this might be depressing too, is that it's counter-cyclical. When the economy is bad and people are getting fired, labor and employment attorneys are very busy. We're at the other end of the economic cycle right now. I mean, I think I saw yesterday jobless claims were at their lowest mark in like a century or something like that. Our issues are around retention now, keeping high qualified people. And you saw hints of this in that Ninth Circuit case. I think where the activity is going to be and where I would be concerned from a risk management perspective, hiring, firing, the traditional stuff, yeah. But in terms of policy, big picture initiatives, I think the focus in the litigation is going to be around terms and conditions of employment, specifically around pay equity issues. And so that's number one, that we'll see an uptick in activity both on the litigation side and at OFCCP around pay equity. Number two, next year's 50 years of Title IX. We're going to get some new regs, there's no doubt. There are hints that advocacy groups are like, we're going to file a lot of lawsuits in a lot of different areas, especially around athletics, gender equity in athletics and all that sort of stuff. I would expect, I hate to say this, because I know we've been dealing, Title IX has been at the focal point for a long time in higher ed, but it's not going away. And I think next year we'll see an increase in activity, but not on the due process side of things, on the equity side of the house. I alluded to this as schools start talking about DEI programs and what they're doing, especially around employment. We're starting to see a bit of a backlash on that. And so just making sure that what we're doing in the DEI space goes as far as is legally permissible, having nuanced DEI programs. And we've done a lot of sessions on that. I'd be happy to talk to you all if you have questions about it. Athletics, no more needs to be said. We talked about that ad nauseum. It'll be interesting to see how this plays itself out, both on the contract for employee side and on the quote-unquote student athlete / employee athlete issue. And then the last part of this is one of the things I think COVID has fundamentally changed, and as I do this from my bedroom, is, I'm not sure we're ever going to be in a position where employees are going to want to come into work, into the office, and certainly a healthy percentage of employees over some period of time will be working remotely. And there's some really interesting legal issues involving that. I saw somebody in the chat mention it, and this is one. Well, what is the application of workers' comp in that sort of situation? That's going to be a state-by-state analysis. I think the more interesting one is around data protection and privacy and, ensuring that, hey, we minimize the risk of data breaches on the employment side. But the fact of the matter is, this is a historically important development in terms of how employees relate and work and provide services to their employers, including colleges and universities. And we need to probably just come to grips with that and go, all right, if they're going to be working from home, what are some of the legal issues? Workers' comp is one. Again, I think data privacy and ensuring that our confidential information is protected is another big one. One last poll question. What is the greatest live performance of all time? Nirvana at the Reading Festival, Radiohead at Bonnaroo, or Soundgarden at Lollapalooza, or, I'm not trying to persuade you either way, but Scott and Sammy today. What was the best?
Have you
I
been to
swear
all
I'd
these?
better. Yeah, well, I have. Yes, actually, I have. All right. Oh, man, that's
Boom.
rude. Whoever's the 18 boy. But we won. I guess I'll take the 72.7%. But there's something about my underlying psychological condition. What I will do is focus on the 28% of you all who thought there was something better than this. Look, I have to do this closing script. You all have been delightful. Thank you for joining our program today. We hope, Sammy and I both hope, the information provided was helpful for you and the university. If you have questions, I'm going to go through those questions, send you an email. Don't hesitate to reach out via email or pick up the phone and call me. Happy to do it. As a reminder, the program is pending approval for CLE credit. Please download the certificate of attendance from the certificate widget at the bottom of your screen, and a recording of the webcast will be available tomorrow for watching and sharing and enjoying over the Christmas holidays. Once it's available, a link to the recording will be emailed to you all. That was awesome. Thank you all so much. I hope you have a wonderful holiday season, and look forward to working with you all next year. Take care.